I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, first order of business is to approve the agenda. The only adjustment that I need to make on the adjustment or the agenda is in consent agenda, letter A. We do not have the November 13, 2019 special meeting minutes in the packet.
I'll move to approve without the meetings from the regular meeting.
Okay, I got a motion by Rick Seiler to approve the agenda as presented, except for that one deletion.
I'll second.
We got a second by Maggie Bass. There's no other questions. All in favor say aye.
Aye.
Any opposition? Okay, the agenda is approved. First thing on the agenda, we will be opening a public hearing. And for the public that's here, the public hearing is due to the vacation of certain easements on that property. And when Ken goes through this, really what the council is looking at today is not anything regarding the plat or anything on that property, because that needs to go to the planning commission. Is that this week or next week?
This Wednesday.
This Wednesday, the planning commission will be reviewing that, and then we'll be coming in front of the council on the 2nd.
Don't want to say that for sure, sometime in December.
Okay.
All right.
Sounds good. Okay, Ken, if you would start us off?
All right, so as was introduced back on October 21st, we have an ordinance vacation hearing tonight for the vacation of easements around two existing platted lots on Highview 10th edition. They're outlined in blue on the overhead there. Kwik Trip is proposing a development on 6.5 acres, which we'll review at the Planning Commission meeting on Wednesday. The specific easements we're looking to vacate are just the perimeter easements on these two lots. They're 10-foot wide easements around the perimeter of that lot. And they would be replaced by new easements when Kwik Trip's plat is reviewed, again, starting this Wednesday for that review. Utility companies have been notified of the easement vacation. I have not heard of any issues with the easement vacations. And with that, I really don't have any other comments. We have an ordinance in front of you tonight that we would be looking to adopt pending, meaning we would not file that until a plat for the lot is approved, again, which will be reviewed at a future meeting by the council. But we wanted to get this ball rolling, as this would have been a condition and is a condition should the plat be approved. So this is just wiping out easements that exist today, and they would be replaced by easements in any plat. Should that plat not be approved, this ordinance would not move forward. This is pending that approval, and the ordinance actually notes that specifically in the language is pending the plat approval.
Okay, sounds good. With that, I guess I will open the meeting up to a public hearing. If anyone wants to make any comments regarding the vacation of these easements. If you want to make any comments, please come to the podium, state your name and address, and direct your questions or concerns to the council.
Hi, Chantal Gastelin, 1001 Phillip Parkway, New Prague. And I don't know if it's a concern or a question, but can I ask if the easements are depleted or abandoned, what would the new ones be? What the purpose is, how it would affect the public? I guess what's the purpose of
They're for private and public utilities for electric, gas, water, sewer. And right now there's nothing in the easements, and they would be replaced with the exact same easement around the perimeter of the property.
Okay, so just because there was no utilities before is why we need to do easements?
It's a standard practice that on any new lot we have easements around the perimeter, and these two lots have them existing, and that would be going through some proposed parking lot and a drive aisle and things like that, where they're not in the place they need to be for the new development.
Okay, forgive me, this is uncharted water here. If you swam in my waters, you'd get it. But yes, so then the new easements, would that affect say, the neighboring people, the public, anything like that? Do you see
No, they're
anything?
just on the lot that would be created with the plat. And again, we'll be reviewing that plat on Wednesday night. Planning Commission and then council, likely sometime in December.
Okay, so what would
It's just
actually go there would be determined once that plat gets approved,
Correct.
if it gets approved?
Yep.
Okay. Perfect, thank you.
Any other comments? Okay, if not, I guess I'll make a motion to close the public hearing.
I'll second.
Second by Maggie Bass. All in favor of closing public hearing, say aye.
Aye.
Any opposition? Okay, the public hearing is closed. Now we need to address this would be the second reading?
Second reading, yep.
Second reading of the ordinance. Again, as Ken mentioned, this ordinance, it has language in it that is pending on the approval of the plat by the Planning Commission and the City Council. Is that
Correct.
correct? Okay. Does anyone have any questions for Ken from the council?
No, I don't.
Nothing?
No, move to approve.
Okay. I will second. I get a motion by Rick Seiler, second by Chuck Nicolai, to approve the second reading of the ordinance. Again, with that language that the ordinance will be pending until approval of the plat by the Planning Commission and eventually the City Council. So with that, if there's no other comments,
I would just make a comment that this is not an unusual request. This happens from time to time. And, as an example, if someone wants to build a house on 2 lots, that would be the similar circumstance maybe that a residence would do. So that's my only comment.
okay, noted. Anything else? If not, all in favor say aye.
Aye.
Any opposition? Okay, passes 5-0 for that vacation. Thank you, Kim. Jim, it looks like you're next on the agenda.
Honorable Mayor and Council, I'm here this evening just to give you a little update on our body worn camera policy. As stated in the memo, we have worked through an evaluation process and have decided on Axon camera platform to utilize for our department. This platform gives us a lot of positives. Its full service functionality of this system allows for easy use, downloading, tagging of photos, long-term management with designated retention periods, and automatic deletion of those vehicles after that retention period. As part of the state statute, it is mandated that we take public input with this process. So ultimately, I'm asking the council to allow continuation of this process with the presentation of a policy at the next council meeting on December 2nd, and then to allow for public input at that time. As part of that public input, the statute also indicates that you must be able to receive it electronically. So upon your approval of continuing or allowing this process to continue, I would also post it on our website to direct any comments to my email, and I'll probably post it on our Facebook with heavy emphasis to make the comments to my email and not on Facebook.
Is there any other advertising, Jim, like in the paper? Just telling people that it's on the website, or?
I wouldn't, no, I didn't. The statute doesn't require you to publish it.
It's not the normal public hearing requirement that comes with zoning or some other items. The only requirement, as you can see in the intent statute, is that we're required to provide for the opportunity for public comment at a regular council meeting. I'm hoping the news media will pick up the story in their summary of tonight's meeting that there's a draft policy in front of the council, and that it can be viewed on the city's website, and comments can either be provided in written format, or people can appear at the December 2nd meeting to provide for that input, but we can try to put that out on our website materials.
I was just thinking an effort to get even more people. Not everybody goes to the website, some people don't have Facebook, but I think if we get it in the paper, I think that would be good enough.
Has city attorney reviewed this yet?
It's been sent to the city attorney, yeah, I should get that this week
Okay.
sometime.
But it's also modeled after the policy that he wrote for the city of Fairfield.
Okay.
So was this actually drafted by the attorney?
No, I went through the several copies that I had. League of Minnesota Cities has a model policy. The Post Board has a model policy. The police union has a model policy. I reviewed all of those along with several department policies in our area. And then also I got a hold of Faribault because our recent officer that we hired came from there and they had Axon. So through a combining of those, that's what I put together our policy so far. So it'll be reviewed by the city attorney, and then with public input, we will look at any changes that we need to do and then put it in place.
So if we proceed, then you're going to make a presentation and we'll have a hearing at the same time?
That's the idea. That's,
Okay.
yeah, right now this is draft. I mean, I'll talk about any others, and I'll, at that time, I would present any public input that I have received to date.
Some of the questions I might have at that time, just give you a heads up if you cared to hear.
Or you can take some of those tonight.
Again,
The council can do that tonight if you would like. That
You can ask
tonight,
questions.
you can certainly ask questions in the consideration of the policy. We don't have to wait until the December 2nd meeting.
Okay.
So
But we'll still have a public.
You're free to ask.
Well, I'm not sure if you want to take questions now or you're going to wait
I
for the
can,
hearing.
if you have some, I can attempt to answer them. Sure.
I think it'd be helpful to me maybe at that meeting if you could run through some examples of some of your typical stops and things, and whether those would create an instance where you would turn the camera on or not. So if someone has a vehicle lockout, would you turn the camera on there? If you have a medical thing, would you turn the camera on there? So we have kind of an understanding of real life examples of when you would turn it on and off.
Generally, I mean, as the policy states now, generally it is if you're going to have a public contact. But there are some of the exceptions in there that if you're in a hospital, generally we would do that. I mean, sometimes we get called to mail to assist with a disorderly patient, and we might have to use some sort of use of force on that patient to contain the situation. We would activate it then.
Only at the time that might be happening, or because it was a personal contact right off the bat? you turn it on?
Well, we may right off the bat, but in situations like that at various facilities, whether that's a hospital or jail has different rules, then some of that may place that video into a different category as private, or before we could release anything from that video, we would have to redact more information from it. But on a general motorist assist that somebody flags us down and asks for directions, probably would not activate it.
So it's not really personal contact, because you're making personal contact all the time.
Right,
So you
yeah.
would be
It would-
offering a little more guidance as far as what.
Yeah, it would be more in an instance that where there could be a physical or you experience some resistance from that person. We would want to document any evidentiary items that we could in that contact.
Are juveniles treated differently in any of this?
They are.
So underage drinking or whatever have you?
If we were, well, because there may be juveniles in that video again, that might classify it as something different as private, or if it's an ongoing investigation, it could be confidential up until everything is charged out and we are done with the investigation. Then it may go to private and only people within that video it may be released to. Some of those videos would be public, but yeah, it's our responsibility to redact any video that should not have people, bystanders or observers or somebody not involved in the incident would be redacted from those videos before they would be released.
Before they're released or once they're loaded into it? So if you had a criminal activity that someone ran into your property, did something, and you were on the video as a bystander, would you be erased before it gets put onto the cloud, or not until someone asks?
No, the full video is the evidence that law enforcement or those that need to look at it would utilize. Say for instance, we responded to the school for a fight, and several officers responded, they had their cameras on, took care of the situation, and went and downloaded their video. That video, each one of those videos is the evidentiary video. Now, if somebody asked for a data release of that, then we would have to go through and redact other students that were not involved, possibly teachers that were not involved in the incident. We would blur out and buzz up.
The other area that gave me some concern was the data security safeguards. Personally owned devices, including but not limited to computable devices, should not be programmed, specifically without approval of chief of police. I'm trying to think of a case where we would ever allow that to happen.
We wouldn't. That's why it's in the policy that personal. We issued smartphones now to our officers in anticipation. We utilize them with other apps. There are some apps that go along with this platform where you can open up your video, tag what type of category it is. But that would be the point, that we would only utilize our
So
work phone.
should that be taken out of this draft policy?
Well, there may be cases, not necessarily. Sometimes you may utilize a cell phone or something else for taking a picture or something. For instance, if our squad cameras were down and their smartphone was dead, they could utilize their personal cell phone to take those pictures. The problem with that is there are logistics about criminal justice information, but if it is something that is needed for evidence, then I would rather have them take them, get them downloaded, and clean them off their phone.
I'm not sure that applies to this policy, because this policy says used to access or view.
Yeah, I think part of the reason that would be in there is there may be a situation where it may need to be allowed. That if you have an officer working undercover or something, that they would be utilizing a phone of their own. Then, in that instance, I may have to authorize the use of that phone for
To be able to look at these videos.
to look at it, or possibly, yeah, to access this platform from their phone. This platform also offers the ability to engage citizens, because everybody has a cell phone and everybody's recording everything. While we're on scene, we can get an email address from them, send them a link, and they're able to download video or pictures right to our account then, and then those are tagged with the case number and attached in there also.
Maybe this is something for the attorney, but I guess I'm generally concerned about some private device having access to the cloud and manipulating it or corrupting it so it can't become evidence then, or it makes it questionable. I guess I don't understand the details of that, but I just
Well,
The personal device and computers is not seem to fit with any of this.
for the platform, Axon is vetted by the BCA and where they need to be with that. So if you're on a citizen complaint like that, all they are able to do is just to download to that link. They can't get into it and do anything else with it in regards to that. For our work, even if they were given permission to utilize a personal cell phone for some of these apps, they would still be going through the same access with their authentication and password that they would be able to get in and utilize it. But again, I don't see that that's gonna happen very often, but that's why it's in the policy that it could need to happen.
So they wouldn't be able to download any information from this access?
They could view videos that are theirs. And that's how it's set up, that each officer only has access to their video. If there are several officers at a scene and there's multiple videos, they could share it with one another. But generally, they only have access to their videos that they've done. And normally that's enough access, because when they're writing a report and want to review their video, they're writing their report about what they did. Doesn't necessarily require them to have to look at somebody else's video, because they're recalling what they saw, what they did. But, yeah.
How's that around my head a little bit, but that does,
They're encrypted from A to B, so they can't be interrupted, so you can't take a little chunk of it. You'd have to take the whole video and then offer your, if they hacked it, right? Is that what your word was, is them hacking it?
no, I'm just concerned about any personal device where you don't have any security and the city has no ability to gain access to a personal device. I don't understand the program enough to know if there's any ability to do anything besides just view it, and if there really isn't an ability to download it. I don't understand that part of it, but.
Well, and again, I put, that's part of the policy right now, just because there may be an instance where it's necessary for them to get permission to utilize some personal device. But, right, I agree with you, Bruce, that as a general policy, we don't want any criminal justice information on personal devices, because then that just opens up to.
And I think we also want to maintain the integrity of the program, and we don't want necessarily officers to be viewing things at home and having other people walk by, or if they're in a coffee shop and they're on their personal device and say, hey, look at this.
Some of that is addressed in the policy also, that authorized use only for valid reasons that you're going to be utilizing that. I think there's part of it in there is about if you share or attempt to share a video, you could be sanctioned for that also.
And then the person erasing or modifying, redacting, is that a responsibility of somebody that's not an officer or what position would be doing that activity?
The management would either be a supervisor position. We can give some of those privileges as we set up accounts. If it were to be a records person, that could be an assignment for that person also. So it would really depend. The idea is we have 2 or 3 people in our office because somebody needs to be there and address the issue and be able to take care of it. So it could be a civilian or a sworn officer.
Or even consider, maybe think about having 2 people, one doing it, one initialing it, that's been oversaw, or
Yep.
just concerned about.
Well, overall, before anything would be released, I would authorize the release of it. So, yeah. this does take on its own responsibilities, and the videos do need to be viewed for any public requests to make sure that we're not releasing data that we should not. And I would have to state whether or not it's appropriate and be justified by Chapter 13 with data privacy.
Does the original stay intact?
That was my question, exactly. You know, so always that backup copy, so
Yep.
you have it redacted in it.
Yep, as soon as you start redacting anything out of it, it's another copy then of that redacted, and the original stays intact as the original file. This platform is nice in the fact that when we do share with the county attorney, we can just click that we are going to share with another agency. Scott County Attorney will get a notice that, hey, you have a video available. When they take that video into their account, then it becomes theirs also. It wasn't original from us, an original to them, but now they're managing their video, and we would maintain our video with what we need to do. Last week at a chief's meeting, it was just brought up about the county attorney would like to see everybody go to evidence.com because it does make for great functionality and easy video sharing. Some departments are moving all their audio and photos to that also because that's able to be shared. They have different requirements. If they charge out a felony, they have to maintain that a lot longer than we have to in law enforcement. They have to maintain it for 15 or more years. We would generally, in most felony charges, we maintain that record for 7 years, and then we can destroy some of the file from there.
Is that by state statute, or is
Yeah.
that just very?
No, it's the auditor's retention policy that they have in state statute. That's what we generally follow.
And I'd like to clarify something as well. So I was always under the assumption that when an officer started their shift, they turned that camera on, and then occasionally turned it off for a various reason or something. That's not the case? So the camera stays off until what point? Them getting out of the car and going up to the traffic stop? Or?
No, they can turn the camera on, and it is functioning, running, buffering, but not recording, okay? So we have, through our trial period here, we have signs downstairs that, hey, turn off your camera when you come into the office. When they leave, there's a sign on the door, turn on your camera as you leave. So they turn it on, so it's in standby mode at that time. Once they make a traffic stop, they can hit their button and it'll go out and then it's recording. But yeah, the idea is it's buffering all the time. So when they hit that button, there's settings on it. We have it set for, it goes back 30 seconds and has audio and video from that 30 seconds till when they activate it.
Is that 30 seconds standard, or is that the max that you can buy?
The max is 2 minutes.
Okay.
So departments across the country utilize anywhere from the 30 seconds to the 2 minutes.
How did you determine 30 seconds? Because I personally just have it 2 minutes and going back, so you can actually see the traffic stop, or you can.
Well, in that 30 seconds, generally you would see that, because they're going to make the approach. The idea is they're following it, they're going to call out, and they would be making that approach within 30 seconds. I chose 30 seconds because 30 seconds is generally enough to get a response from them if they see a violation, unless they're following that car for several miles or a couple miles to get more driving conduct. But 30 is just something more than, start-stop time.
Well, some of the complaints that I've heard from residents is that there's things like, oh, your license plate was blink, or your license plate light blinked and there's a short in it, or, you know, you didn't signal 125 feet before a turn, and when in fact, I don't know how you can even determine 125 feet, if, you know, you're guessing basically. But those are the type of things that if we had 2 minutes, that could squelch a lot of the complaints that I get from residents that feel like they're being followed and being pulled over for really, really minor things, including even rolling stops or something. If we had that, it'd be real easy for them to come in and, here's the tape. You rolled through the stop, or there's your blinker, you did not blinker. Or
Yeah,
whatever it might be.
and with the body cams, I was hoping it was a little better than that. You don't always get out that windshield and see driving conduct. Squad cameras are another thing that would be an option. I chose not to pursue that right now because they're about 10 grand a squad. But,
Well, if the,
Because where does the body cam sit?
well, by policy, they're supposed to mount it someplace that's appropriate to get the best view, and center chest here is generally pretty good. So they're able to, where they turn and view, generally that is on the camera then. And it's, the view is kind of a fisheye type, it's a wide lens, so that's where it's going.
I guess my personal feeling is that we have the capacity to tape for 2 minutes or for this to buffer, and then if we need it, we could go back 2 minutes would be the way to look, if that's the maximum. Unless there's some storage reason or something that, you know.
Well, storage becomes an issue, but yeah, I mean, we can look at that.
But I think what you're hoping to find, you're not gonna see, because if you're sitting there and you have a steering wheel in front of you, you're not gonna see a burned out tail light maybe, or something as they're.
That's true, it could be.
So,
but-
I mean, I don't assume that you're gonna drop that
Oh, no.
segment of.
I just think any more information is
Right.
good. So the more information we can have, the better. And you're right, it might not catch that, and that might be.
I think within that 30 seconds that they're driving up, I mean, depending on what the issue is, but a no tail light or a tail light out or something, that
Or
will be
blinking
caught.
or something,
Yeah,
then to-
yeah, the short may not be caught because they're not moving anymore, they're stopped and.
Right.
And they're
But I mean, I've had them literally where they've gone in to get it investigated and it was not. I just want to make sure that they're being stopped for
Oh,
that
that reason.
and not being, because it's 11:30 at night on a Friday,
Yeah.
you know, so.
My only question on this whole thing is, what if there's an incident that the police want to cover up and they just never hit their cams? I mean, I wish that there was always buffering so that we could always see it and yeah, put 2 minutes on it or whatever. I mean, so that we could have a way to substantiate what the PD's doing. I don't know when you do that with personnel reasons.
Yeah, well, the only thing I can do in my policy is address that if they are not activating it when they're supposed to, then it would be a disciplinary issue that would go on.
So there's no way that we could do it so that the dispatcher could call a unit and send them over to one of the apartment buildings and activate it at that point of dispatch?
Not right now in our technology that we have, no.
Who is,
So, Chief, thank you. So Chief, I see here I understand that this is a draft policy that is, except as otherwise directed, that the officers have discretion to record or not to record. You know, there are listed here certain instances where recording must take place. I think maybe that's where the policy could get locked down a little bit better,
Okay.
so that there isn't quite as much discretion. I think just for some of the things that we've been hearing from the other council members, obviously incidents that have happened in other cities where recording was not done, and it would have been critical to the investigation. So I think just to really, if you're recording and there's nothing really horrible going on, so then you erase the recording or you file it in a certain area that, right? So it's,
Yep.
I don't think it's
Yeah, there's,
It inhibits the use of the application and
the use of it.
Yeah.
Yeah. If something happened in a traffic contact, a verbal warning, that would be the idea that they tag it as a verbal warning, and that retention period is set at 180 days or whatever
Right.
that is. So yeah, that becomes shorter. If they meet resistance with that person and it becomes a use of force issue, well, then it would go to a longer retention period because of
Right,
that.
right, yeah. Again, it's just a concern that they have the discretion to record or not to record. And I realize that you can't control every situation, and individuals are forgetful, but it would be nice to ensure that if a traffic stop is made, if an encounter with a citizen in their home or their yard, that camera is operational.
And I think most of the officers are at that point, because we have them, you're going to record your interactions, generally.
Right, yeah.
And,
It's just
and
the
again,
words in the policy.
yeah.
Although there are not page numbers here, Jim, we need to get that in the final policy that would, now if we don't even discuss it, it talks about officers shall activate their cameras when responding to all calls for service and during all law
Right.
enforcement related encounters and activities.
Yeah,
So
I read that as well, but it's the second one, it's B, that kind of then contradicts A.
Yeah, when it talks about incidental citizen contacts, as far as if somebody asks for directions or,
Right,
you know, they need a tow truck or something like that, in those situations, I think that's what that's saying is that they don't need to record those type of calls.
Right, but for the officer's safety, what if a motorist flags an officer down and it looks that as if the vehicle needs to be towed or it's run out of gas or something, and that citizen has bad intentions and they try to hurt your officer, wouldn't you want that on camera also?
Yes, and in that instance, when they have a concern for safety, more than likely they're going to activate that and have that on at that time. We don't know just pulling up to something if all they're going to do is ask us a question for directions.
Right.
You don't know that. So in most situations, any public contact, they're going to turn it on and have that on video.
Okay, all right, thank you.
And once it's videoed, it can't be deleted by that officer?
Nope. All they can do is tag it with the appropriate information that they're supposed to by policy, and then it gets, when they bring it into the office and drop it into the docking station, that's when it gets downloaded and sent up to the cloud then.
Is it possible when you come with the final draft and looking for approval to actually have,
Bring
well, and actually show us what a video
Yep.
would look like?
Yep.
You know, the resolution and things like that, so, you know, kind of give us an understanding what it looks like?
Yeah, as part of the presentation. I can
Yes,
do that. Yep.
okay.
Who does the audit that's prescribed in this policy?
We as a city have to hire somebody to do that audit.
So is it like the ECA or the?
No, there are private firms out there that, because it was written in the state statute, believe they can make some money, so they provide the service.
Not like accounting firm?
Retired officers, there is an office, or not an officer, she is an employee at Burkesville Police Department who's been introduced at our chief's meeting. She's providing the service at a real reasonable rate compared to what others have come out with. But it'll range from $700 to $3,700.
Okay, it's not like 5 or 10,000?
No.
Okay. Then I didn't understand this sentence. Right. Employees may observe their own VWC videos on accident view, which is non-discoverable. Does that mean that no one can know how many times that person viewed it?
Where are you reading from, Bruce?
The last page, E, The second sentence. So it looks like it must be a, like, what you might use on your cell phone possibly versus.
It is an app on your cell phone. You can view on there, and you can also tag your photos with that. So,
Change it.
yeah, your smartphone is talking to your camera via Bluetooth, and that's how you're viewing it. You're seeing it streamed from there, and then you're also just tagging it and telling it what you want to put on there.
So the non-discoverable conduit, does that mean that you can't go back in a court case and see how many times did the officer actually look at it?
Yeah, non-discoverable would mean, yeah, for the defense to say, well, how many times did he watch it? I don't know that that's necessarily an issue. Through the policy, they have the right to view their video before making reports also. But anytime you actually log into evidence.com through that account, that has a running audit on who watched the video at what time. Because when I review videos right now, that's something that shows up on the screen that says being viewed by this user at this time.
So action capture must be, is that a word for the computer then, or is that actually when they download it from their cell phone?
Well, the action capture is the ability to actually capture evidence on your smartphone, or if you were going to take still photos, then you're capturing evidence for that.
And that is discoverable. So
Yes, because that would upload, and it's going to tell you what device, when it was downloaded, and the circumstances around it.
Okay, so if X and View was on their personal cell phone, they could look at it, and no one would know that they're doing
Yes.
it. Okay. All right.
Okay. Any other questions?
Do we need to take a vote on the buffering capacity if the council would like to see 2 minutes, or leave it at 30 seconds, or?
I think we can talk about it at our next meeting, and if it's input, we can look at it then.
Okay, thank you.
Awesome.
All right?
Okay, thank you, James. Mike, I think you're going to take the next item.
Yes. What you have in front of you is updated information as it relates to the acquisition of the temporary easements and the process that we initiated back in August regarding the condemnation of the 12 temporary easements that we were unable to acquire on a voluntary basis. So if you recall, back on August 5th, we sought authorization from you to proceed with the use of eminent domain proceedings on 12 of the 121 temporary easements that we had not successfully acquired. We did acquire 109, or about 90% of them, and so the 12 remaining was about 10% of those that we weren't able to acquire. Following the initiation of the actual eminent domain proceedings under our city attorney's office, we were able, subsequent to that, to also then settle 6 of those 12 voluntarily. So we're only still proceeding with the actual acquisition of 6 of those. One of those property owners, parcel number 20, elected to engage an attorney in the process, and in going through and working to try to settle that one, they reached agreement between our city attorney's office and the attorney that the property owner engaged. And so that's why you see on your action item tonight is to approve a stipulation of settlement agreement with, it should be HZ, not 2, HZ Homes, LLC, parcel 20. And so the amount of the settlement in that agreement is recommended by the city attorney, and the agreement with the property owner is at $3,000. All the items I'm talking about tonight for dollar amounts of what we're proposing to pay is all reimbursement 100% by MnDOT as part of our acquisition of temporary easement right-of-way for the 2020 project. So in that agreement, that's contained in your packet. Essentially what it is the payment under section 2.2 on page 4. The settlement amount is $4,000. The next items in preparation.
3,000.
I'm sorry, 3,000, excuse me. Following that, on October 22nd and 24th, we were able to present our condemnation actions to both the Scott County District Court and the LeSueur County District Court, respectively. At those hearings, there were no objections that were received, and we were able to obtain approval on the findings of fact, conclusions of law, and obtained order approving petition and transfer of title and possession for the 6 remaining temporary easements that were needed. So we have obtained those orders from the 2 district court actions. Now the next step in the process and proceeding is preparations to deal with the dollar amount of the acquisitions, and as such will be needing to go before a condemnation jury. One was appointed in LeSueur County with 3 individuals. Subsequent to find out one individual is not going to be able to do it, so they're finding a replacement for that. And then there's conversations with Scott County to see if the same impaneled 3-member condemnation jury can serve for both Scott County and LeSueur County to maintain some consistency in that process, so we don't have a separate one on each side of the dividing line between LeSueur and Scott County. I've not heard from the city attorney's office whether that's been accomplished or not. In that process, to move forward, of the remaining 6 to be acquired, one of them is a commercial property that involves also the closure of one of the access points from that property to the highway, and MnDOT is wanting for that to be closed. And due to the extent of what's needed to prepare that one is that it will require a more formalized before and after market value appraisal at a much higher cost, and that's the one with the Messner, Patch and Messner valuation counselors. That's being recommended by the city attorney's office. Have reviewed that with MnDOT, and they concur as well. They've had good success with using Mr. Jason Messner of this firm for these type of matters. The other 5 are all residential in nature, and we're proposing that we use Ms. Kelly Lindstrom, who was involved in doing the initial valuation and the appraisal work that was done to determine the valuations of all of the temporary easements. And that's at a substantially lower price at about $3,000 a report, and we've got 5 of those that we have to do. And MnDOT is in concurrence with doing that as well. Those costs will all be reimbursed by MnDOT in the process. And then lastly, in order to actually take physical ownership under the quick take process, as you can see in items E and F in the packet that I've laid out for you, and these, the only page that was not copied was basically the signature page by the Robert Lindahl, who's the attorney out of the city attorney's office. And so what we have to do is we actually have to write the final checks and either post them with the court, or they have to be provided to the individuals, and he's trying to do the process that will make it easiest for these property owners to get the checks. And so, as you can see in the first one, on his letter dated November 11th regarding the settlement on parcel 20, as far as posting the check, that needs to be payable to both the property owner and their legal counsel. On the other 2 there is made payable to parcel owner number 47 and parcel owner number 52. On the Seward County side. And then on the Scott County side, we've got 4 parcels that we have to do that for. And so for parcels 59, 90, 100, and 95, you can see in the letter that we have to make those payable to individuals, as well as in the one to the Scott County District Court Administrator in the different amounts. So the action ultimately, as I laid out in my memo to you, is to, number 1 is to approve the stipulation of settlement agreement with HZ Homes LLC, or parcel number 20. B is the authorize the hiring of appraisers for the 6 parcels that I've so noted. And then C is authorizing the issuance of the quick take payments and deposits for the 6 remaining parcels.
Okay. Anyone have any questions? Yes, we're going to do individually. So, if there's no other questions or not, I guess I'll make a motion to approve the settlement agreement with HZ Homes.
Second.
Got a second by Sean Ryan. There's no other comments on that. All in favor, say aye. Aye. Any opposition? Okay, passes 5-0. Next, I'm looking for a motion on hiring the 2 appraisers.
So moved.
A motion by Sean Ryan,
Second.
second by Rick Seiler. There's no comments, questions. All in favor, say aye. Aye. Any opposition? Okay, that passes 5-0. And the last is basically putting a quick take payments and deposit them for the remaining parcels in a total of $48.70.
So moved.
I got a motion by Maggie Bass,
Second.
second by Bruce Wolf. There's no other questions or comments. All in favor, say aye. Aye. Any opposition? Okay, passes 5-0. Thank you, Mike. Next on the agenda is the consent agenda. Remember, we did remove the November 13th special meeting minutes. So does anyone have any questions, issues, and anything in the consent agenda?
I have a quick one. In the accounts payable, Mike, the violation of private data with the League of Minnesota Cities Insurance Trust.
Yep.
Is that an ongoing?
Nope, this is the last one, going back to 2013-14, when we got into that, and so this is the last remaining one. Actions were finalized in the court system handled by the League with no detrimental impact to us back in September. And so as they finalized out everything with all the other cities that were involved in this one particular incident, they're now billing out those costs, and so we're having to pay our deductible that, for that incident going back to 2013-14.
Do you recall what the total cost was? Was it just the 2,500, or was it?
2,500 per year. No, not per year, but it was per incident with the individuals involved, and I think we had about 6. And so over that time period from 2013-14 till now is where we've had to, as they've worked their way through the whole judicial process, appeal system and everything, depending on what the plaintiffs chose to look into on the lookup of those records, has resulted in various timeframes for those being settled with all the different jurisdictions that were involved in that. So this is our last one.
Anything else?
I just had a general question about the calendar. Is there a process, or meetings ever change once this is adopted?
Generally, for them to be changed, it would be by action of that individual governing body, and typically we're notified of that before they move forward with it.
What time frame do you need, the 2 weeks prior to the meeting?
We have to make sure that, and typically most of the board of commissions know of that, at least 1 to 2 meetings in advance of that occurring, in most cases.
As a housekeeping, I know we may be missing 2 meetings, so in the interest, some sometime in the future, if you need to count heads for quorum purposes, do we discuss ahead of time, or do we share that information?
Yeah, typically, the council has let each other know if that's occurring, so that we don't put ourselves in that position. I think we came close once, but I don't know that we've had to ever cancel a meeting because we didn't have a quorum, but the council's pretty good about letting letting
Yeah, I don't
themselves
think
know.
since I've been mayor that we've ever had to cancel a meeting because of, no, lack of quorum.
Okay.
So it's just communication. Okay. Anything else? Any other questions, issues on the consent agenda? I will second a motion by Rick Saller, second by Chuck Nicolai. There's no other comments or questions. All in favor of approving the consent agenda, say aye.
Aye.
Aye. Any opposition? Okay, passes 5-0. Miscellaneous. Does anyone want to speak to the council at all? No? Okay, Mitch, you got anything?
Nope.
And I don't even know your name.
Andrea Nelson.
Okay, do you want to make any comments or questions?
No?
I assume you're representing the New Prague Times?
Yes, I am. Yeah.
Well, welcome. Jim?
Just that we do ride-alongs. We have a form that people sign off and can do a ride-along. Generally, it has to be for a purpose if you're going into law enforcement or something. I just wanted to extend that to the council members, that if you wanted to do a ride-along, we could schedule something up. Just get a hold of me.
Okay.
You have to be in the back seat.
Huh? Generally in the front.
Thank you.
With handcuffs.
With no body cam either. Ken?
Nope.
Michael?
No, other than just a reminder, December 2nd will be a very full agenda, likely.
Okay. Sounds good. Barb?
No.
You're all quiet today, Barb.
Not anything.
John? Nope. Rick?
Happy Thanksgiving to everybody, and the newsletter is him and then me in January. Is that right, Barb?
No, I have January.
How can you have January when you had November?
And I had December. Usually what I do in December is I kind of summarize what happened. And in January, I kind of just welcome everyone to the new year, and then we start the normal cycle.
So are you gonna come up with a new schedule at that point?
Yes, I can send it out.
Yeah. You get every other one.
I'm just thinking that's, I mean, that's just straight.
It wasn't so, it was worse when I had to do every one. That's it, Rick?
Yep, that's it.
Bruce?
More a housekeeping question. When I think some of us received the email from a community member regarding Kwik trip. What point, what circumstances would we include that as part of the hearing? When we get an official or something coming through our emails, city emails?
If they would request that that be read into the record at the public hearing for the planning commission,
So
I would need to know that they want it read into the record at a specific meeting, correct?
Just, okay.
Yep. So if you want to follow up with that resident and see if they would like that, then we can do that. Or they can attend the meeting too.
Well,
But just
I think I was
because,
comfortable with what was said, but then you said that other part, which I wasn't comfortable. I don't know, you're suggesting that the onus would be on us to get back to that?
No, I'm not
answer?
saying that. If you want to offer that, that's, if you would like to, but no, generally speaking, we'll get comments and say, please read it into the record.
Yeah.
At the meeting.
And that's pretty obvious.
Yeah.
but
This
generally,
is pointed in, comment.
but just because that comes, as you as an individual respond, is that you're not able to respond on behalf of the council as a whole.
Right.
So if you're responding individually, that's correspondence between you and whoever you receive that from. And just because that occurs doesn't necessarily mean that we would insert that into the materials that we have unless either you or that individual would want that information posted in there.
Yeah, that's fine. I mean, in this case, it was addressed to each individual council member. So-
Correct, understand that sharing of information with you, but the council can't act in a capacity that a majority would be doing anything other than you individually responding if you have any thoughts. And generally, we would encourage you to, to be careful about that response until you've heard or received the information concerning the development so that you know more of the information that goes with that.
So me, myself, and I aren't a quorum.
Right.
Right.
It
That's why a lot of times
depends
if
on
you
how
just
long
do
you're
a
going to argue.
reply- If you do a reply, it's a lot better than reply all.
It should not be reply all.
Because if you do a reply all, then you're kind of including everyone who was attached to that, and it could be all the council, and someone could misunderstand that as you guys are talking about something
Oh,
as a quorum, because if there's a conversation going back and that stuff. so.
Yeah, I just thought there may be a gray line when someone addresses each council member as a group individually. They're really addressing the issue that they would at a public hearing, but the public doesn't have the opportunity to know what that person said or what they're doing.
Well, as you saw in that as well, is that staff was not included on that mailing either. So technically, we're not aware of that until we got your response that you sent individually.
Right.
Okay, anything else? Okay, I don't have anything, so I guess I'll make a motion to adjourn.
second.
Second by Rick Seiler. If there's no other comments, all in favor of adjournment, say aye.
Aye.
Aye. Any opposition? We're out of here. Thank you, everyone.
Happy Thanksgiving, everybody.